All right, and we're recording. Okay, Robert, why don't you take it away?
Okay, thank you for inviting me today. I'm Bob Friedman. I've been an estate planning and probate attorney at Friedman Ranzenhofer for 42 years. We've always felt that it's very important to educate our clients and the public about their legal rights, and we do this through on a regular basis, presenting webinars and seminars. And for additional information, we have all sorts of educational resources on our website, wny-lawyers.com, including legal guides, blogs. We have our past webinars and seminars on the website. As always, I just have a few warnings before we get started that this is not a substitute for legal, tax, or investment advice. You need to consult with your own advisors to see what's best in your particular situation. The law is constantly changing and is subject to different interpretations. The purpose today is to dispel myths and make sure your wishes are carried out. And when you do go to talk to your advisors, your investment, your tax, and your legal advisors, you know what questions to ask. So each particular case is different, so you need to consult with your own advisors. You can't just go by what you may have heard that your neighbors experienced as far as paying for nursing home costs and so forth. So we have, first off, the overriding consideration is that many of our clients want to preserve their assets in case they go into a nursing home by making gifts during their lifetime. But the reality is, and what you need to think about is that if you want to get into a good nursing home, that you may not want to make gifts, and you may want to have substantial assets still in your name because even though nursing homes cannot discriminate against Medicaid patients, they do. So if you've made gifts in the past 5 years or have considerably less than $100,000 at your disposal, you're going to have a tough time finding an appropriate nursing home. No one wants to go to a nursing home and no one wants to send their family to a nursing home, but people say, I will never send my mother to a nursing home. But a couple of things can arise. Things can go downhill very quickly. Someone breaks their hip. They go into rehab and then they go into long-term care. They never return home. Or being a caregiver is very difficult. It's very physically and emotionally very stressful. And some people are just not cut out for it or don't have the mental or physical stamina to be a caregiver. So we do still need to plan on going to a nursing home just in case some calamity arises or you don't have someone that can be your caregiver. So a situation is if you want to get into a good nursing home, and even some of the 5-star top rated nursing homes are not that great. If you want to get into a nursing home of your choice or have your loved one get into a nursing home of your choice, then you may not want to be making gifts and you may want to have substantial assets at your disposal. So Medicaid is a program to provide for care both at home and assisted living in certain instances and cost of skilled nursing care. So you have to be pretty much impoverished, and there's all sorts of exceptions, which we'll talk about. There's exceptions to the exceptions. That's why you need to talk to an advisor that knows your entire family situation and what your assets are and how they're owned and so forth. There's various situations to see if there's any other disabled people in your household. So Medicaid is a federal program. We're not talking about Medicare. We're talking about Medicaid to pay for nursing home care, in-home care, or assisted living care. So you have to be pretty much impoverished. We'll talk about the exceptions for if you're married and certain assets don't count. But if you're in a nursing home, you can only keep $50 a month in your income. And for in-home care, it's $884. Now, New York, unlike some other states, such as North Carolina, you will still qualify for Medicaid, even if you have income above these limits. And as I said, you have to be impoverished. So you can only have resources of $15,900 if you're single. And we're going to talk about many exceptions to this. There are certain things you can have in addition, or your spouse can have in addition to the $15,900. So many of you may have heard about the look back period. And this is 5 years when someone applies for Medicaid, for assisted living or for a nursing home. You have to fill out an application regarding your finances for the past 5 years and provide bank statements for the past 5 years. Now, for community or in-home Medicaid, there is no look back period yet. It was supposed to go into effect earlier this year, but now it's not going to be going into effect until next spring or next summer as far as for in-home care. So it's something you need to talk to about with your advisors. It's a 5-year look back period that when an application is made for Medicaid. So what does this all mean about the look back period? Well, if you've made transfers of assets, gifts within the past 5 years, it could disqualify you from Medicaid for a certain period of time, which means you will have to private pay. So this results in what they call a penalty period. So if someone's made gifts of $110,000 over the past 5 years, now this could be gifts of cash, or if you were to transfer your home, your $500,000 home to your son for $10, that's considered a gift too if you transfer assets and don't receive consideration in exchange. So if you've made a total of gifts of $110,000 over the past 5 years, each part of New York State has their average cost of nursing home used to determine what the penalty period is. And that changes every year. It depends on the part of the state. In Western New York, it's $11,054. Downstate, it's quite a bit more. But in other words, if someone's made gifts of $110,000 in the Western New York area, then they would be penalized in not being able to receive Medicaid for nursing home care or assisted living for 10 months. So one of the ways of getting around this is to properly document gifts. So there's a presumption that if you've transferred assets 5 years before needing Medicaid, that you transferred it for the purpose of qualifying for Medicaid. That's a presumption. You can challenge that and ask for a hearing regarding that. So in the most cases, transfers or gifts 5 years before going to a nursing home may disqualify you from Medicaid for a certain period of time. Therefore, I recommend that you have regular medical checkups to show that you were healthy when you made these gifts. It varies from county to county, but generally withdrawals from accounts under $1,000, they will not ask for documentation. So when you submit your Medicaid application and they see your bank accounts, they will be asking for documentation, usually of any withdrawals of $1,000 or more. That's just a general rule. It could be withdrawals of much less also. You're going to have to provide documentation of what you did with that money. Now, many of you may have heard about where you can give away $15,000 per year. I think most people have heard about that. Well, that has nothing to do with Medicaid. That is the U.S. estate tax exemption. So you can give away $15,000 to as many people as you want every year, or $30,000 if you're married, and not have to file a gift tax return, a U.S. Gift tax return. This is part of the U.S. estate and gift tax return system that right now the exemption is $11.7 million. $11.7 million exemption for estate and gift tax. So we would rarely have clients that would have that problem. But what this really means is that in addition to $11.7 million, you can give away $15,000 per year to as many people as you want. But that will still disqualify you from Medicaid. It has nothing to do with Medicaid qualification. And as I said, if you're married, you can give away $30,000 to as many people as you want without you or the donee having to report it. So in all this scenario of whether your gifts were made, transferred for the purpose of qualifying for Medicaid, they'll look at past patterns. If you, as on a regular basis, make gifts to children or grandchildren for birthdays or weddings, those sorts of things, those types of gifts will not be considered in disqualifying you from Medicaid. There are protections. Secondly, there are protections if a nursing home patient is married and has a spouse, husband or wife that's still living at home. There are protections where that spouse at home will still have enough to live on. And the spouse at home can have resources up to $130,000. Now, this is in addition to the house, which we're going to talk about. These are resources in addition to the house that the spouse at home can keep. Income of at least $3,259 combined income. And on top of that, even if you have $2 million and your wife is in the nursing home, you can file a spousal refusal or refuse to support your spouse, and your spouse that's in a nursing home, husband or wife, will still qualify for Medicaid. However, you could be sued in family court by the county attorney to recoup the cost of Medicaid. So the reason why I say nursing homes don't like Medicaid patients is that the private pay rate, at least upstate, is probably like $500 per day. They only get reimbursed $200 per day for Medicaid by Medicaid. So in other words, they prefer to have private pay patients as much as possible. So if you refuse to support your spouse, you will be sued by the county at the $250 a day rate. So it's something to speak with your advisors about if you have excess resources that may disqualify your husband or wife from nursing home Medicaid. Update your will. So generally, you can't disinherit your spouse. So if you have a husband or wife in the nursing home, then you need to update your will. You don't want to leave everything, because usually most wills, husband would leave everything to his wife. And you don't want to do that because it's difficult to predict what's going to happen. If the husband who's at home dies first, and everything will go to the wife, and which will in turn go to the nursing home or reimbursement to Medicaid for past Medicaid paid. So you should speak with an attorney about updating your will. Generally, you can't disinherit your spouse unless your spouse has signed a prenup, or if your spouse has abandoned you for 1 year. But if you do disinherit your spouse in your will, your spouse has what's known as a right of election. So what that means is that your spouse can file a right of election if you disinherit him or her to receive what they're entitled to under law, which is at least $50,000 and up to 1/3 of your estate. So how this works in Medicaid is that if a nursing home patient's spouse disinherits them, the county will file the right of election on behalf of the spouse to get 1/3 of the estate, so that they can be reimbursed for Medicaid. But still, you should revise your will. I do a presentation, and I have those presentations on our website about avoiding probate, and there's pros and cons to that. But when we do advise clients about wills, we need to see what the ownership of their assets is. And there's many assets that do not go through probate. So basically, your will only covers assets that are in your name alone, where there's no beneficiaries. There's pros and cons of that you need to discuss with your advisors. But non-probate assets, so regardless of what your will says about these non-probate assets, your will has no control over certain assets. Life insurance is payable to the beneficiaries upon presentation of a claim. However, if your beneficiaries are all deceased, then your life insurance will be payable to your estate. So sometimes we have people that name their mother as a beneficiary back in the 50s, and they never updated their will. So there are no living beneficiaries. In that case, the life insurance is payable to their estate. And IRAs, as long as you have living beneficiaries, for tax reasons and otherwise, also for protection for Medicaid, it's a non-probate assets with death benefits. Various forms of bank accounts are non-probate. They just go to the survivor. Joint accounts, there's payable on death, there's in trust bank accounts. Additionally, you can transfer one automobile up to $25,000 without going through probate by submitting an affidavit to the New York DMV with a death certificate. One vehicle up to $25,000. We'll talk about living trusts. Your investment accounts, your stock accounts, starting back about 10, 15 years ago, can be transfer on death. It usually states it on the statement that you can name who will receive your investment accounts upon your death, transfer on death, rather than going through your will or through probate. So very often we get calls from people that don't need our services for probate because all of their assets are non-probate. We'll talk about some of these other assets that are non-probate and what the consequences of that are. So if you learn one thing today, that should be that you should have a power of attorney. And just not any power of attorney, but a power of attorney with gifting powers. So powers of attorney are only valid during your lifetime. Upon your death, they're no longer valid. They can go into effect either immediately when you and your agent sign them, or they can be springing powers of attorney. 99% of our clients have immediate powers of attorney. Springing powers of attorney do not go into effect until a future event occurs, such as a doctor signing a certification that you're incapacitated. So it's a little more cumbersome. Some people are paranoid and prefer a springing power of attorney. But otherwise, if they're not a springing power of attorney, they go into effect immediately. So powers of attorney can avoid the need for guardianships. We call Article 81 guardianships for incapacitated people, which are can be expensive and time consuming. So there's been two major changes in the power of attorney law, but if you have powers of attorney that were prepared prior to that, they're still effective. So there was a major change in the power of attorney law this past June 13th, a new format. Basically, one of the purposes of the new format was to set up a procedure where if banks refuse to accept powers of attorney, they could be sued. Okay, banks must accept your power of attorney form as long as they are satisfied it's valid and you present them with an original. If they refuse to accept it after going through various procedures, then they can be sued. So this is new law effective June 13th. Just a couple things to note about the new law. The new powers of attorney authorize gifts up to $5,000 per year made by your agent, unless you designate otherwise. So that doesn't do you much good as far as what we're going to call emergency Medicaid planning. We're going to talk about at the end. You should have a power of attorney that contains a modification that allows for gifts in excess of $5,000, for instance, for estate planning or emergency Medicaid planning. So anyway, prior to June, there was a major change in powers of attorney in 2009. Prior to that, powers of attorney used to be 1 or 2 pages. Now they're about 8 or 9 pages long. So the law back in 2009, major change there was the agents also had to sign the power of attorney. You can appoint 1 or more agents. You can appoint 1 or more successor agents. You can designate whether those agents must act together or whether they can act separately, such as if you had 1 agent in Hawaii and 1 agent in New York, you may want them to be able to act separately. So the 2009 change, there was one of the major changes. Other change, what there's a statutory gift rider, which authorized back then. Gifts were only authorized up to $500 per year, unless you sign the gift rider, which became a little cumbersome. So anyway, just something to be aware of depending on when your power of attorney was executed. And it's really important that you have it done correctly and it's on the correct form, and not an office supply form, because it can be very helpful, and avoid the need to have to go through guardianship proceedings to do some of these things we're going to be talking about, where you can preserve your assets. Certain transfers are permitted to certain relatives, and certain gifts are permitted, even when someone's already in a nursing home. Long-term care insurance.
Robert, can you hear me? Sorry, we have a question. Somebody asked, do you recommend single agent or multiple agents?
Well, it's going to all depend on your circumstances, whether it's single agent or a multiple agents. So it depends on how, well, first of all, how much you trust them, but it should be someone that you trust anyway. And whether or not they're able to act independently or not. So it's going to depend on your particular situation as to how available they are and how helpful they're going to be. The new law does require agents to act as fiduciaries, similar to an executor or a trustee. They must act in your best interests. And they also can be required to account after someone passes away. They can be required to account to other family members. Or if a guardian is appointed, sometimes the guardianship is still necessary, even if we have untrustworthy agents, that they would have to account to the guardian. Long-term care insurance. There's the traditional plans, and there's also plans that you can discuss with an investment advisor, hybrid plans, combining life insurance and long-term care insurance. If you have a New York partnership plan, then the advantage of that is that when the policy runs out, you will qualify for Medicaid regardless of how much you have. Even if you have $3 million, you will still qualify for Medicaid, regardless of what you own with a New York partnership plan. There's fewer and fewer companies that are offering it. I still do advise it. Medicaid requirements are going to be tightened up more and more. I think in many counties, most of your tax dollars go to Medicaid. So there's the regulations are going to tighten up. Get long-term care insurance while you're healthy and that you can qualify for it. And it covers in-home care, which may be difficult to obtain Medicaid coverage for that. It covers assisted living and skilled nursing care. So there's, many of our clients, their primary asset is their house that they want to protect. So there's a number of protections for your home, to protect your home in case you have to go to a nursing home. One of those is people transfer their current home to their children with a life estate deed. So a new deed is prepared. They transfer the house to their child and keep life use, which means they're still entitled to their property tax exemptions. They have right to occupy it or rent it out. No one can put them out. And upon their death, it automatically passes to their children. So that's a non-probate asset. So fewer and fewer people are doing that. As an alternative, that we're talking about living trust. There are some drawbacks to a life estate deed, some serious consequences. One of those is if your children, so your children are on the deed, you deed it to your children and you reserve life use. If your children go bankrupt, and I've seen it happen, then a substantial amount of money will have to be paid to the bankruptcy court. If the owner is 85 or 90 years old, their interest in the house, their life estate interest is only worth about no more than maybe 10%. So if it's a $300,000 house, their interest is only $30,000, and the remainder is the children's, and that could be subject to the bankruptcy trustee taking control of that or be paid that amount. Another drawback is that if the children are sued, there could be judgment liens against the house. And also, if you decide you want to move south or you want to sell your house, then you have to start all over again with the 5-year look back period. And we'll explain in the living trusts how that avoids all those problems of the life estate deed. So life estate deed, most people instead of that are transferring their house to a living trust. We'll talk about that in a moment. Another alternative is you sell your current house and you purchase a life estate interest in your child's house, or you buy a new house with your children. As long as you're living there for a year, the house is protected. That usually doesn't work out. That's available, but as far as the numbers go, as far as what you're selling your old house for and investing in a new house, it usually doesn't work out, but it is an option. That's where you sell your house with this other option. Also, the primary residence, your primary residence is exempt. It's not considered in these resources. When I talked about the $15,900 resources. And just keep in mind, you can transfer whatever you want, as much as you want, to your spouse, and there's no penalty for that. So there's a $906,000 equity exemption in your house, which you or your spouse would be entitled to, which would, as far as qualifying for Medicaid. If you're single and you've been in a nursing home for more than 6 months, you will lose that equity exemption because it's presumed that you're not going back home. But initially you would be entitled to that exemption, or you could transfer the house to your spouse. So that's why I say it's important to have a power of attorney. One spouse cannot transfer the house to another one without signing it themselves. And if they're incapacitated, then a guardian or the power of attorney must sign for them. So there's another valuable use of a power of attorney. If your husband or wife cannot sign the deed to sign it over to you when they go into a nursing home, then you're going to have a guardian appointed to do that. You can transfer a house or anything else to minor disabled or blind children. There's no limit on that. There's no look back period. Just keep this in mind. That's why when we talk to our clients, we need to know if there's any disabled family members. There's no penalty for transferring assets to, including the house, to disabled people. And that includes after someone passes away too, to avoid Medicaid recovery. If someone that's inheriting from someone that's been in a nursing home is disabled, they're protected, and their inheritance is protected from Medicaid recovery. Another protection is if you have a brother or sister that's living with you and they live with you for at least for the past year, you can transfer the house to them and there's no penalty for that if they've been living there for 1 year. And what they mean by an equity interest is they've been helping out with the expenses. There again, another protection if you have a brother or sister that's been living with you for a year before you go into a nursing home. A caregiver child, this happens quite often. A caregiver child that's been residing there for the past 2 years. Usually the caregiver children have been living there for 50 years or all their lives, but if the caregiver child's been there for the past 2 years, the house can be transferred to that caregiver child at any time. There's no penalty for that. There's no 5-year look back period for that. So a caregiver child that's been living on the premises, there's really no documentation required that they are the caregiver, but if that's their primary residence, that should qualify. Living trusts, Susie Orman says everyone needs living trusts. That's not necessarily true. There's no specific dollar amount, but living or inter vivos trusts can be revocable or irrevocable. Now for Medicaid protection, they have to be irrevocable. And advantage of living trust is if your children go bankrupt or are sued and you put your house in living trust, it does not affect the trust at all. It doesn't affect your house at all. And if you decide you want to move, the living trust sells your house and buys you another house in the name of the trust. So living trust, you prepare an agreement in which you put control of your assets, whichever assets you put in the trust. We put the house in the trust by deeding that you would deed the trust, you would deed your house to the trustees of your trust. The trustees for an irrevocable trust have to be someone other than yourselves for Medicaid protection. So it's usually children, one or more children are the trustees, and you provide in the trust that the trust creator can live in the trust, live in the house, so they will still be entitled to property tax exemptions, your STAR exemptions, veterans exemptions, and it'll be similar to a will. It'll provide what's going to happen when both of the creators pass away, how the assets will be divided up there in the trust, or the trust can continue on to manage assets for minor children or grandchildren. You can have a prepaid funeral account of any amount that's not considered in this resources for qualifying for Medicaid. IRAs that are in a payout status are not considered to be your resources. So I'm seeing more and more people have $500,000, $1 million IRAs or 401ks. Those are not considered your resources. The distributions from them will be considered income that may have to go to the nursing home, but the principal of the IRAs are not considered to be resources. Talk to your investment advisors too. You can obtain, this is something was legalized a few years ago, qualified longevity annuity contracts. If you want to reduce the amount of distributions that have to be made legally from your IRA, you can look into it, a qualified longevity annuity contract. So IRAs are rolled over usually to your beneficiaries. IRAs are non-probate assets unless the beneficiaries are deceased. You really don't want it to be a probate asset. You can delay paying of income tax by having beneficiaries on that who can roll those over. So something to keep in mind too about IRAs, if you're paying for instance, in-home care that's not covered by Medicaid, and some people would rather find home care aides on their own as opposed to going through an agency. I'm not a real big fan of agencies. They often hire convicted felons, which we've had cases where they have stolen large amounts from people they're caring for. But anyway, something to keep in mind. So if you hire private or aides on your own rather than going through an agency, you're gonna have to private pay for in-home care. But just keep in mind that IRAs should be the very last things that you should tap into in paying aides and so forth. So in case you do have to go into a nursing home, that IRAs will be protected because they're not considered a resource. And in addition to that, there's no estate recovery against IRAs, non-probate assets. Another important thing about non-probate assets, which I talked about before, is that when a nursing home patient passes away, the county cannot go against non-probate assets to recoup Medicaid that they've paid. They can only go against probate assets. Another consideration when you're speaking with your advisors. Caregiver agreements, for instance, you've cared for your father for the past year, taking care of financial and personal needs, and your father pays you for your time because you had to take time off from work, and you were there 40 hours a week caring for your father. Is this considered a gift if your father pays you? Well, yes, it will be considered a gift, which could result in a penalty. The only way to pay a caregiver would be, not the only way, but the way to do this would be a caregiver agreement, which can avoid family disputes. A caregiver agreement must define the duties of what you're doing and so it can be payment in advance. It could be payment in a year in advance for your caregiver duties. Just a couple drawbacks to caregiver agreements is that the county social services departments really hate caregiver agreements. So they will really scrutinize these quite carefully. So if you're going to do that, make sure it's prepared by an attorney who knows how to prepare caregiver agreements. And the caregiver does have to pay income tax on the payment as caregiver. As I said, you can make unlimited transfers to disabled children. These could be, if they are SSI or Medicaid, it could be set up in a supplemental needs trust, so it does not jeopardize their Medicaid or SSI payments. Same way as you could provide in your will for disposition to disabled beneficiaries who are on SSI or on Medicaid, if you wanted to provide them with trust that can pay for luxury items, then it can be set up in your will also to be put into a special needs trust. You can spend down your assets. There is no, your one auto is not considered a resource in the calculation of the $15,900. Pay off debts, make home improvements. So emergency Medicaid planning and promissory notes. So this is why I emphasize that you need to have a power of attorney with gifting powers. So someone, that's why I say it's one of the most important things you can have is to have this power of attorney. So, and not all powers of attorney are going to be helpful. They have to have the unlimited gifting powers. So generally when we meet with clients about wills, we do recommend powers of attorney, and we do, and if they have powers of attorney, we just review their powers of attorney, make sure they do have the gifting powers. So basically with emergency Medicaid planning, this is someone that's never done any planning. They're already in a nursing home, and they have substantial assets. It could be either a house or large bank accounts. So regardless of what you put on your nursing home application, we always counsel clients to not hide any assets. You have to reveal everything in the nursing home, regardless of what you reveal the nursing home or on, you can still make gifts. So as far as hiding assets, first of all, we don't encourage people to lie on Medicaid applications. So that's a criminal offense. And we've seen many instances where people keep considerable amounts of cash, very large amounts of cash in their house, either that they don't trust banks or they don't trust other people. But we had a couple estates where people had hundreds of thousands of dollars in cash in their house. Another case where someone, home health care aid through an agency stole $90,000 from the person. And they were criminally prosecuted, which is very rare. They just did some stupid things why they were able to, but it's very rare to be able to prosecute home health care aids is still cash. But this home health care aid did some stupid things by putting the money in a safe deposit box in a bank and by posting some things on Facebook. So they were able to prosecute him for about half of what he stole. But regardless, so with emergency Medicaid planning, the situation is that, and this has to be done with the guidance of an attorney, it involves 2 Medicaid applications. So basically with emergency Medicaid planning, once you're in a nursing home, and this would have to be done via your power of attorney would have to do this for you if you're incapacitated, or a guardian would have to be appointed. So what you do is, and it's a very precise calculation, so you do need someone that's familiar with these promissory notes. So you give your assets away to your children, and they sign a promissory note to repay half of it to you. It's a precise calculation based on your debts and what your nursing home costs are. They sign a promissory note promising to pay you back, and those monthly payments go to your nursing home care, so that it involves 2 Medicaid applications. You complete a Medicaid application originally when you do the gift, and you get turned down. You do want to get turned down the first time. And then when you're the half of your assets run out and the promissory note is paid, you will qualify for Medicaid, and you reapply for Medicaid and you will qualify. So this is commonly done. So what happens, we come across many people that, even though they have powers of attorney, they don't have gifting powers in that. So we have to do guardianship proceedings in a state Supreme Court in the particular county to have a guardian appointed that can make these gifts on behalf of the people. So these are widely accepted. The judges will, Supreme Court justices will order this gifting with a promissory note to preserve half the assets. The nursing homes can't kick you out. It's perfectly legal and accepted practice. So the judge can empower the guardian to make the gifts and do the Medicaid applications. So this can be very useful, and the procedure in Supreme Court could take a few months. So time is of the essence. And if the only asset is a house, the house will have to be sold in order to liquidate the house to be able to set this promissory note up. So something to keep in mind as far as the importance of powers of attorney. So healthcare proxies and living wills, you have a constitutional right to refuse medical treatment. But how are you going to express that if you become incapacitated? Well, the way to do that is through what's called advance directives. And there's 3 types of advance directives. There's a healthcare proxy, in which you appoint a healthcare agent to make healthcare decisions on your behalf. That came about through New York legislation. There's also a living will, which gives your particular directions. If you don't want tube feeding or artificial hydration, then you have to include that in your living will. Your healthcare proxy does not have that authority to discontinue tube feeding or artificial hydration unless you have it in your living will. Also, your healthcare proxy should have a HIPAA authorization, so that your healthcare proxy doesn't really have access to your medical records without that. There are also HIPAA authorizations in the power of attorney, which is important if you need to discuss, if your agent needs to discuss your medical billing with your medical providers. So, the other advance directive is most medical orders for life-sustaining treatment, also known as physician's orders for life-sustaining treatment. So that's a situation. So you need to understand, a healthcare proxy is only enforceable in a nursing home or a hospital. So if the EMTs come to your home, they have to revive you, unless you have doctor's orders like a DNR, which is signed by a doctor, or a medical order for life-sustaining treatment. You complete that with your doctor, and you indicate you do not want to be revived. You don't want to be revived. So people that are at home with under hospice care may not want to be revived. So they would fill out a MOST form, medical order for life-sustaining treatment. So if the paramedics or EMTs come to their home, that will direct them not to revive them if they don't want to be revived. Same with the your healthcare agent can request that your doctor sign a DNR. That's signed by your doctor, do not resuscitate order, that would indicate that you do not want to be revived and breathing or your heartbeat for a particular medical procedure. So that's something to discuss with your healthcare agent. So in 2010, New York passed the Family Healthcare Decisions Act, which authorizes your domestic partners or children or others to make healthcare decisions for you. That's all the more reason to have a healthcare proxy, because if you don't have a healthcare proxy, other people, such as any of your children, would be empowered to make healthcare decisions for you, and they may know what your wishes are. So that's something that you should keep in mind in having a healthcare proxy, and both a healthcare proxy and a living will make sure that your wishes are carried out. So it looks like we're, as I said, I have further details of this. We have any questions here? I guess not.
Thank you. That was great. There was a question in the chat, and it says, can you explain on why life estates are typically not financially viable?
I'm sorry, what was that?
The chat said, can you,
take a look?
I'm sorry. Can you read it, or do you want me to read it?
Yes, could you read it for me? Thanks.
Sure. It says, can you expand on why life estates are typically not financially viable?
Sure. Okay. So it's more basically the life estates, the risks with life estates, with deeding the house. Well, the two major things is deeding the house to children who may be financially irresponsible, who may go bankrupt. And we've seen that happen. Sometimes we've had children that don't even list the house on their bankruptcy petitions, and the bankruptcy cases had to be reopened and the old records brought up. So that could put the house in great jeopardy in having to repay the bankruptcy trustee, because that would be considered an asset of the child. They have what's with a life estate. Usually the parent is known as a life tenant, and then the other the children who it's deeded to are the known as the remainder men or remainder people. So if they're sued or if they go bankrupt, it does affect the real estate. So what people have done, I mean, most people do living trusts. Some still do life estate deeds. What some people have done is that if they have more than one child, they will deed the house to the child least likely to go bankrupt. And so the title is just the remainder title is just in that child's name, and then the child signs an agreement which is recorded that they will share the proceeds of the sale of the house after the parents are gone, so that the other children are protected. And then the other risk was that if you decide you want to sell the house, then you would have to start all over again with a 5-year look back period, because you would have the money would come back to you, or some of the money would come back to you, and then you would have to start all over again and buy another house. With a trust, the trust is on the title to the house, and the trust sells the house. The money stays in the trust, and the trust will buy you another house. So people get these trust agreements set up. The living trusts do not do you any good unless you fund the trust. So the assets have to be put in the name of the trust. So to do that for the real estate, you would deed your house, prepare a new deed. You deed your house to the trustees, and they have the title to it. You can also put other assets. You would not put IRAs in that. That's something you need to talk with your advisors whether your assets can be put into a trust. You would not put IRAs in there or annuities. You can put your investment accounts in the name of the trust, and therefore it becomes a non-probate asset and would pass to the beneficiaries, for instance, listed in your living trust. So, and that has to be irrevocable. Some people do revocable trusts just to avoid probate. There's pros and cons to avoiding probate, but they're depending on where you are on the probate, depending on what county you are in, the probate process can be very quick and efficient, or it can take a long time. We do probate all across the state, and there's vast differences in the way the courts are acting. For instance, Kings County, people wait months and months and months. I know attorneys have told me they've waited, they're still waiting on papers that they filed in January. But normally, it should only take a couple months. The big thing about, big misunderstanding about probate is people think, and we get these questions all the time, people think that the will itself grants them authority as executor. So when someone passes away, the executor can't march into the bank and say, I'm the executor, because that's what the will says. The executor does not have any authority until certain papers are filed, certain people sign off, or certain people are served, and the court's satisfied that that is a valid will. Then they will appoint the executor and issue certificates for that. So that process can take, as I said, it can take 2 months, it can take a year, and before the executor who's given the power to gather the assets and pay off the debts is given any power. So very often everything is in limbo. The relatives may have to pay expenses themselves. So there are advantages to avoiding probate with such things as the life estate deed or the living trust. But that's something you should talk with your advisors and see what's best for your situation.
Thanks. So I had a question. So the power of attorney is for when the person is alive, right? And you can have one or two, and then you can have a successor after that. And then if that person passes, then the executor takes over. Is that correct?
Right. Yes. Correct. Yeah. So yeah, the power of attorney automatically ceases upon the person's death, or unless they revoke it. And then there could be some limbo there if it's all probate assets where no one will have control over anything until the executor is actually granted authority certificates from the surrogates court. And it all depends on the particular county that you're in. Usually, in some counties it can be very quick, just a couple of months. Who has to be notified? So that's an important thing. So what people need to understand is that regardless of what your will says, there are certain people that have to either sign off or be cited to appear in court to be given an opportunity to object to the will. So New York has intestacy laws which provide who inherits if you have no will, which they have a whole structure for that. So those people who would inherit if you had no will are still part of this process. They either have to sign a waiver saying they have no objection to the will, or they have to be given an opportunity to come to court. Because if the will is thrown out, these people under the intestacy laws would inherit. So, we have situations sometimes where second cousins may be the closest relatives, and the person may, even while they're alive, may not even know, and then may have seen these people for 50 years and had no idea where they are. These people have to be made part of the process. So in those particular situations, then, possibly there are advantages to avoiding probate and putting your assets in non-probate assets, such as a trust, so you don't have to go through these court procedures. The advantage of probate is you can change your mind right up to the last minute about who you're leaving your estate to, whatever your most recent will is. So there's a whole series of considerations you have to talk to with your advisors about whether trusts are best for you and these other non-probate assets. The advantage of the living trusts And you can also set up trusts in your will to go in effect upon your death as managing assets beyond for younger children and grandchildren until they are more responsible, so they're not receiving receiving their inheritance all at once.
All right, does anyone else have any questions? No? Okay, well, thank you so much for this presentation, very informative. I want to say you've cleared things up, but I think you put it out there. So now I know I have personally a ton of questions on what needs to happen. But thank you again for your time and doing this presentation. I really appreciate it.
Yes,
And
thank
just
you. Yes, thank you for your attention. And if you want any further information, or if you want to submit me any questions, you can submit those on our contact forms on wny-lawyers.com, and I will get those directly.
yeah, and his information, everyone, is right in the Outlook reminder that I sent for the presentation. All right. Thanks again. Thanks, everyone.
You're
I'm gonna
very welcome.
stop recording.